We're talking discovery here, not admissibility. You may disclose it and none of it's admissible because there's nothing in it. For example, if they give opinion A on the stand and there's a transcript in another case they said not A, that's permissible impeachment of their opinion to go in and say, well, in State versus Smith, didn't you say X, Y, and Z? And now you're saying A, B, C. I think that's permissible impeachment. And if you have transcripts, I think discovery-wise, Mr. Nelson's entitled to them.
But what I'm saying is, until that witness says not A on the witness stand, that prior doesn't, I may be mixing up the court's analogy. Until that witness says A on the witness stand, not A isn't a statement about the case.
Correct.
It's potential impeachment.
Correct.
So there's no duty to disclose that until he says not, until he says A.
I'm telling you to disclose it.
And then I assume the court will be telling the defense to do that as well.
Absolutely. If you have transcripts of somebody's, the other side's witnesses or your own, those should be disclosed. This is in federal court where you have to wait till cross-examination.
Your Honor, that is all of the defendant's motions we were prepared to address today. There are several of our motions that we could address. I don't know if the court wants me to yield the podium or start in on those.
Is there, can we talk about number 33, the spark of life, or did you want to wait for later?
I would prefer to wait, Your Honor.
That's fine.
I mean, spark of life is a very clear to all. I'm hesitant to start into it today because I'm not sure what the contours that defense counsel is thinking of with regard to spark of life testimony. To me, it's straightforward, but I'm just not sure I know exactly what the problem is there. So we did not talk about it ahead of time, and
all right, why don't the two of you talk and we can address it later.
I mean, yeah.
Okay. All right.
So it's my understanding that the other defense motions have not been addressed today. We will address tomorrow or as scheduled.
Subsequent days, correct.
Okay. Do you want me to start on ours, or do you want to?
Mr. Nelson, are you prepared to?
On the states, yes. I'm
Yeah.
ready.
All right. And if you could reference, I will assume on the state's motions that these are from the motions filed February 8th, 2021, unless you tell me otherwise.
That's my, that's what I'm working from, Your Honor.
All right, and these are also numbered, so if we can walk through the numbers, and let's start with things that are not contested. Agreed.
I actually think that the vast majority of these will not be contested, Your Honor.
Okay.
With respect to witness number one, or excuse me, motion number one, we have no objection as to the permissible grounds for impeachment. Would not use a FBI report or a BCA report to impeach a witness who didn't prepare that statement. Number two is one that is going to be contested. It also corresponds to a subsequent filing that I don't have pulled up right now, but number two will be contested.
I think you're talking about the state's second amendment.
Correct.
That were filed on March 4th. Is that correct, Mr. Frank?
It is, Your Honor.
These-
That is motion 2.
Understood. Thank you. Mr. Nelson.
Thank you. Motion number 3, Your Honor, I think is premature. I think that goes to the questions of jury instructions. Obviously would not make any reference to any rules of law that were not contained within jury instructions, but because we have not had a jury instruction conference yet, I think.
Mr. Frank, would you agree with that? And I actually need a microphone by you. Thank you.
Your Honor, the problem I have with waiting, of course, is we will have voir dire, we will have jury, we will have opening statements and witness testimony that could depend on what these concepts are and what they're going to be. So I don't think this is something we can reserve until the end of trial when we're looking at the final jury instructions. Because as part of our motion is, any testimony or argument about essentially incorrect standards of law. So I do think we need to address this certainly before opening statements.
Well, again, my strong position is nobody should be trying to instruct the jury on the law, because that's my job at the end of the case. And so if counsel starts to ask jurors their opinions about what does this charge mean, and use words like but for or intend, that's going to be problematic in jury selection, just to warn you. But Mr. Nelson, do you object to these, or what part do you object to?
No, I don't necessarily object to them, Your Honor. I just think that in terms of what the appropriate legal standards are, we have not thought about those, for lack of a better term. And so in that regard, Your Honor, it's not my customary practice to inquire as to the law or the rules of law in voir dire. And I rarely ever reference any sort of elements in an opening statement. So, it wouldn't be my intention to do that, number one. So if the court wants to grant it subject to a jury instruction conference later, that's fine too.
I think that's the best way to handle it. I'm going to grant it subject to the jury instruction conference, because I assume the state is relying on the substantial factor in causing death.
Correct. And we did submit a memorandum that addresses this motion too.
And I think everyone is in a safe harbor if you rely on the jury instruction guides for elements, generally. And so if these aren't in the jury instruction guides, you are in dangerous waters. So I'll grant it with the understanding that we'll talk about it at our jury instruction conference.
Sounds good. You're on number 4. I'm just thinking that we address that later in the week.
Okay.
Number 5, I think is very similar to the one of our jury instructions. I have no objection to that, Your Honor.
Okay, that's granted without objection.
Number 6, I think, is also part of our ongoing discussions about the training materials that both sides intend to introduce and the reasons for which they may be introduced, whether it to be show that Mr. Chauvin with particular training or policies of the MPD. And so that's just a discussion that we're continuing to have. I think we've made some substantial progress in that regard. And so just asking to reserve it, and if we need to come back to that at a later time.
Any objection to reserving it, Mr. Frank?
No, Your Honor.
All right, that's reserved.
Number 7, I have no objection to that, Your Honor.
Okay. That's granted without objection.
8, no objection.
Granted without objection.
9 is 9, 10 are identical, and they are also identical to one of the defense motions. The court
Right. I
previously
think we've
granted.
already established that you're not going to comment on each other's failure to call a witness. And if the answer to that was to call 400 witnesses, this would not be a 4-week trial. Go ahead.
11. Again, in terms of, I believe that the court has already issued its ruling on all 404B stuff, so it would be no objection to that other than subject to.
Rearming the May 16th.
Yep. Number 12. Again, I have generally no objection to this. However, the state has agreed to provide me with the criminal convictions of witnesses. And if there is any intent to use any prior criminal convictions, we can cross that bridge should we learn about it.
I'll essentially reserve that.
Okay. And I believe that's all of their motions.
Mr. Frank, anything else? You had the second supplemental, but that was basically the reserving on the expert.
Correct, just because we had obtained additional information from the time of the first motion to the second amended motion.
All right. So I didn't count them up, but we've got a handful of motions left to argue more substantively. Is that correct? I'll try and identify them myself. But that's it for today then, as far as motions?
Well, as far as motions, Your Honor, just other than stipulations as to strikes for cause.
Yeah, who wants to, somebody wants to take the podium and,
Your Honor, for the record, again, over the mid-morning and early afternoon break, counsel for the defense state met and conferred and reviewed, agreed upon jury strikes. We are in agreement to strike juror numbers 5 for cause, juror number 11 for cause, 12, 13, 14, 15, 16, 18, 22, 24, 25, 32, 35, 45, 47, and 50. We only made it through the first 50, Your Honor.
no, that's fine. That helps us a lot as far as who to call in. Let me make sure I've got it correctly. 5, 11, 12, 13, 14, 15, 16, 18, 22, 24, 25, 32, 35, 45, 47, and 50. Is that correct? State agree?
That's correct, Your Honor.
All right. Based on the stipulation, we'll release those people for cause. Since I think the parties are obviously being very thoughtful about the proper use of our time in jury selection by identifying these ahead of time, I may reduce the number of jurors we bring in from 16 to possibly 12 or 14. The last trial we did in here in January, which was a murder in the first degree case, we were pretty good at keeping 6 per session, 6 in the morning, 6 in the afternoon, and getting to everybody. So I'm thinking this one we might be able to get, there might still be cause challenges that will be granted. So my thoughts are 7 and 7. But if you have any advice to the court on that, I'm happy to hear from anybody. So, but I think for now we'll go with 7 and 7. All right. Is there anything else for the record today? You can't do it. All right. Anything further, Mr. Nelson?
No, Your Honor.
All right. We are in recess. Tomorrow, the jury has been ordered to report at 8:30. And so we'll try and get started with jury selection by 9 if we have motions at 8. So we will come back at 8. The jury is expected to start with selection at 9. And I'll start that with the basic group discussion or instructions before we go one by one. As I've said to the state, unless the Court of Appeals tells me otherwise, we're going to keep moving. So with that, we're adjourned until 8 a.m. tomorrow. Thank you all.
stuff on the table though, that's a defense counsel, so I'm assuming they'll take care of it.
Greg?
Yep.
So do I just leave this here so they can charge it?
Yep. I'll come and pick it up because I'm gonna put them all on the charger for the night. How's the, Grace, can you tell, how's the audio coming across from
Really
the,
well. So you think it's just my, this speaker?
I thought, I was surprised how soft it was from my perspective, Dana, so I'm glad it's,
Cause I'm like, this is really soft and like I said, there's nothing.
yeah. So I'm glad it's coming across on their feed, but I'm gonna call Andy to come up and see if they can adjust that, because I thought it was pretty soft.
Okay,
So,
this-
there could-
who's
there-
audio?
There could be jurors, back, especially Dana behind,
So,
that,